Okay, so today's topic is criminal law. And I'm going to start off with just kind of identifying the differences between civil and criminal law. So there's just to give you a little bit of clarity. Then we're going to talk about the different types of crimes, talk a little bit about the more serious felony crimes. We're going to talk a little bit about criminal procedure, and then finally, I'm going to talk about the criminal protections that are afforded by the Constitution. Civil law and criminal law have some really distinct differences. Civil law is really about the rights and duties that exist between private parties. Can be individuals, can be organizations, can be some of a mix of that kind. And criminal law is really about conduct that society has deemed so egregious that we have outlawed it entirely. And so it's really about conduct that threatens public safety and welfare. The government prosecutes a crime, and with civil cases, it's the individual who is harmed. And in fact, the victim really doesn't have a say in whether or not the government chooses to prosecute. Once the crime has been committed, the case is not the victim versus the perpetrator, it's the government versus the perpetrator. So even if a victim says, I don't want this person to be prosecuted, the government can say, well, thank you for sharing your thoughts, but we're going to prosecute them anyways. The burden of proof in a criminal case is beyond a reasonable doubt. I talked about that in the last lecture. Versus in civil cases, preponderance of the evidence. You do have to show that you've been harmed or damaged in a civil case. Punishment, criminal law, jails, fines, or some combination of the two. And with respect to civil law, the punished party or the responsible party typically has to pay some kind of damages. So like I said, criminal law is about conduct that is so egregious that society has said we basically cannot tolerate it. All criminal law is statutory in nature. It is created by legislatures, and it is prosecuted by the government, not individuals. Again, the burden of proof, beyond a reasonable doubt, think in that scale in your head, 99.9%. Criminal defendant has a right to a trial by jury for any charge that can result in a sentence of 6 months or longer. A felony is a crime for which a defendant can be sentenced for up to 1 year or more in state prison. And then a misdemeanor is a less serious crime punishable by less than a year in county jail. So up to a year, it's a misdemeanor. Over a year, it's a felony. Frequently, what we see most in criminal law is infractions. And so when you get a speeding ticket, that is an infraction, which is the least serious crime. We might even say it's a bending of the law, not necessarily a breaking of the law. So it goes infraction, misdemeanor, felony. Okay, so let's talk about the major types of criminal offenses. First of all, we have crimes against people. So somebody committing a crime against another person. Probably the most common crime that you might see against someone would be an assault and battery. So a battery is an unwanted touch, and an assault is the fear of an impending battery, and an assault is the fear of an imminent battery. And so criminally, most of the time, law enforcement will charge the assault and not the battery, or they'll just call it assault. But technically, there are two crimes. Assault is the fear, and the battery is the touch. Homicide is when someone takes the life of someone else. That homicide can be intentional, or that homicide can be negligent, meaning that you didn't mean to do it, or the person didn't mean to do it, but they committed some wrong, and as a result, someone else died. For example, someone driving with a suspended license gets in a car accident, and the other party passes away. That's going to be a negligent homicide, also known as manslaughter sometimes. So it just depends on the circumstances of the case and the intent. Looking at crimes against property, the most common crimes against property have to do with theft. Larceny involves the trespassery taking of someone else's property without their permission. For example, you leave your car at the mechanic shop, and while you're gone, the mechanic takes your car and goes out and drives it around town and puts 300 miles on it. That would be larceny. If, however, you go and you take something that belongs to someone else by force, that's going to be robbery, and with the intent of keeping it. That is going to be robbery. Robbery typically is by force. And then embezzlement is when you have access to someone else's property and you convert that property for your own personal purposes. So an accountant working in an organization might have access to the company's checkbook, and then they take that checkbook and they write personal checks to themselves. Technically, that is embezzlement. When someone sells you or gives you stolen property, that is a crime itself. That's a receipt of stolen property. And then there are crimes that relate to fraud or using lies and mistruth in order to acquire someone's property. Forgery, for example. Somebody takes one of my checks, signs my name to it without my permission, and then goes to a check cashing place and cashes it. That is both fraud and forgery. Okay, so let's talk about crimes against property. So burglary is not necessarily a crime against property. What it is the breaking and entering into a dwelling of someone else in order to commit a felony. And so with burglary, technically, you don't have to show that somebody took something. You have to show that they had the intent to. Arson is the malicious burning of a dwelling of another. Arson can be a house. It can be someone's, technically a dwelling, but it could be a house. It could be setting someone's car on fire. It can be, you frequently see arson in cases of businesses that aren't doing very well, and then there's a fire at 2 a.m. mysteriously, and then the owner files an insurance claim. Many times those are cases of arson where the owner has set the building on fire because they weren't doing so well. Bribery is payment for some kind of official action or pay to play. And bribery is actually a pretty serious crime internationally. I will talk about that in a minute. But you can't pay people to make decisions in your favor in a business environment. And then perjury is the act of telling falsehoods in a legal proceeding, lying under oath. There are a lot of crimes that frequently take place in a business setting. So mail fraud and wire fraud. Somebody fraudulently talks someone else into wiring them money. That would be wire fraud. If they fraudulently do this by sending them something in the mail that they get and then it says, wire me some money, blah, 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 then that's actually mail fraud too. Fraudulent activity that takes place through the U.S. postal system is mail fraud. Antitrust crimes are crimes that relate to attempts to monopolize industries. We'll talk more about that when we get to the Security and Exchange laws. Environmental crimes are typically connected with businesses. Illegal dumping of toxic materials, for example. The Foreign Corrupt Practices Act basically says that U.S. businesses cannot bribe foreign officials in order to gain advantages in the marketplace. So basically what that means is that if I'm a business person and I'm doing business with Air France, I can't bribe Air France to come and buy my airplanes. Why? Because Air France is owned in part by the French and the European governments. And so anybody that works for Air France is a foreign official, and the Foreign Corrupt Practices Act specifically addresses foreign officials. Something interesting about the Foreign Corrupt Practices Act, bribery is illegal unless bribery is legal in that country. So if bribery is legal in the country, then you're not violating the Foreign Corrupt Practices Act by bribing someone. And grease payments are legal. A grease payment is typically a payment to speed up the process. And so if it's a grease payment, it's legal. If it's bribing the foreign official, it's not legal unless bribery is legal in that country. RICO, or the Racketeering Influence and Corrupt Organizations Act, basically is a set of laws that were designed to help control the mob. And basically what happens with RICO is that you have crimes that are committed in pursuit of a criminal enterprise. And so it might even involve legitimate business activities, but if the major industry that the legitimate business activities is supporting is a criminal organization, then all of it is illegal. More recently, so I said it started with the mob, more recently RICO has been used with human trafficking laws. And then there are a ton of computer and internet related crimes, phishing, spamming, ransomware. I will talk about that in the following weeks. We will probably have a whole module dedicated to computer crime. I've been accused of a crime. What are my defenses? So frequently you'll frequently hear ignorance of the law is not an excuse, but a mistake of fact can be an excuse. For example, one time when we were coming back from a trip, my husband had a purple suitcase, and we got back at 2 in.the morning, and somebody went and took his suitcase thinking it was theirs, and she got in a taxi, and I can't even remember how the airline figured it out and found her, but she legitimately thought that that was her suitcase. So she didn't commit larceny there. She didn't commit commit any kind of burglary. She simply made a mistake thinking it was hers and it wasn't. So typically something like that is a reasonable defense. Entrapment is basically when you say that I was unduly influenced by law enforcement to commit a crime. With entrapment, what you have to show is, one, that you were truly unduly influenced, and two, that it was not in your nature to commit that kind of crime in the first place. There are a lot of cases where people think that the police, by setting up a sting operation, is entrapping people, and that's not technically the way that entrapment works. There was a case in Michigan several years ago, and it was somebody who had worked in a domestic violence shelter, and they were being accused of identity theft. What happened was that somebody called the police and said that this woman had been stealing people's identities. First of all, what you need to know to start a criminal investigation, all you have to do is call up the police and say, I think so-and-so is doing such and such. So it's very easy to get a criminal investigation started and get somebody in a lot of trouble. So this woman, the police got a tip that this woman was selling people's identities. So a detective went undercover, contacted the woman. It was a domestic violence shelter, and so basically said to the woman, I want to buy the names of your clients, because that's what she was being accused of. And the woman said no. Over a period of 6 months, this police officer continued to get into contact with this woman. If you know anything about domestic violence shelters, they are very secretive about their locations and who their clients are, for very good reason. So the second thing that this officer did was they said, okay, well, the reason why I want these people's information is I'm going to start a shelter in Illinois, and I have really good opportunities for your clients there, and I want to make them an offer to come and come to my shelter for free. And the woman said no. Finally, what happened was that the undercover officer, made another entreaty, and at the end of that entreaty, what they said was, okay, well, just so you know, if any of the women in your shelter gets back to their abuser, if their abuser finds them and they could have been in my shelter in another state, it's going to be on you personally. And at that point, the woman said, okay, I will give you this information. And at that point, she was arrested. The case went to trial, and she was found not guilty by reason of entrapment. And so, as you can see, it takes a lot to get to be found not guilty by reason of entrapment. You have to show that you were not someone who was predisposed to that kind of activity. Duress, meaning that somebody forced you to commit the crime. Duress can be physical, meaning I'm going to hold a gun to your head till you go commit that crime, or it can be financial. I have taken this money from your bank account, and if you don't do this activity for me, I'm not going to put it back. And then lack of capacity, for whatever reason, you don't have the mental or physical ability to commit that crime. Lack of capacity generally tends to be mental. And so, yeah, that's going to be, that I just didn't have the mental facilities to know what I was doing or to understand the consequences of what I was doing. So moving on, states have to follow specific procedures when investigating and prosecuting a crime to ensure that the process is fair to the accused and to society. So in order to make an arrest, the police have to have a reasonable suspicion that a crime has occurred. And that generally means either the officer sees the crime being occurred, or they've received information from an informant, somebody's called the police and said a crime has occurred, and as a result of an investigation, the officer receives a warrant from the court, which gives them the power to make an arrest for the crime that the officer didn't see but was reported to. Once someone has been arrested, there is a preliminary hearing. The preliminary hearing can also be waived by a defendant, and this is where the court determines whether or not there is enough evidence to hold a defendant over for trial. Typically, bail is a constitutional right unless the defendant has been deemed a flight risk. And in that case, then bail can be withheld. If the crime is so serious that the defendant is potentially harmful to society, bail can be withheld in those cases as well. Remember that crimes are always prosecuted by the state, not the individuals. And once the preliminary hearing is held, then you have the arraignment. And this is where the defendant pleads not guilty, guilty, or nolo contendere, which means no contest. Not guilty, I didn't do it. Guilty, I did it. And nolo contendere, or no contest, where you're not admitting guilt, but you're not denying it either. And so once you make your plea, there is a trial if that's required. Many cases criminally are pled out, meaning that the defendant agrees to plead guilty to lesser charges. I'm not going to talk about the criminal trial because it's the same as the litigation process, just with a different standard of proof. So you can go back to that lecture if you want some clarity on that. And then once the judge or the jury makes their decision, the defendant is adjudicated either guilty or not guilty. And so that's basically the criminal trial in a nutshell. Some of the most important criminal protections that you have are Amendments 4 through 8, the rights of the accused, and also the 5th and 14th Amendments to the Constitution require that the language of criminal statutes be clear and definite enough that ordinary people can understand what conduct is prohibited. So they have to be in plain English. And police are discouraged from arbitrary and discriminatory enforcement. So, Fourth Amendment, illegal search and seizure, prohibits the government from making illegal searches and seizures of individuals, corporations, partnerships, and other organizations. And the goal of the Fourth Amendment is to protect the individual from the all-powerful. And under the Fourth Amendment, it says that the police can only obtain a warrant if they have probable cause, which means that it's likely that evidence of a crime will be found in the place to be searched. Searches without a warrant are possible under 7 circumstances. The officer sees something in plain view that indicates that you have committed a crime. In stop and frisk situations, So a police officer, if they're pulling you over for a lawful stop, has the right to pull you out of the car and frisk you for their safety. In the case of emergencies, so a crime has just happened, the police have the ability to investigate or to solve that caper, so to speak, that's happening right in front of them. There are cars are allowed to be searched if the officer has probable cause of wrongdoing. In a lawful arrest, if you consent to a search, and in places where there is no expectation of privacy. Courts have said, for example, kids at school don't have an expectation of privacy. The Fifth Amendment protects criminal defendants, both the innocent and the guilty. First of all, due process requires fundamental fairness at all stages of the case. The government has to follow procedures in order to adjudicate you guilty. Self-incrimination bars the government from forcing a person to provide evidence against themselves. The Miranda rights are part of the Fifth Amendment, meaning you have a right to remain silent when you are arrested. And a criminal defendant may only be prosecuted once for a particular criminal offense. Once you have been found not guilty of a crime, the government cannot re-prosecute you for that same crime. Sixth Amendment is your right to a speedy trial. The government has to try the defendant speedily. That can and sometimes is waived by the defendant. A lot of times in larger cases when the defense needs more time to put on a case, many times the right to a speedy trial is waived. You always have the right to an attorney in the criminal process. The government has to appoint a lawyer to represent you free of charge for a defendant that cannot afford one. And defendants have the right to confront their accusers in court. And then the Eighth Amendment prohibits cruel and unusual punishment. And that's it. So end of lecture. What'd you learn? What'd you take away? What can you apply to your life?